The Supreme Court is about to hear another major Second Amendment case. This case is about laws that restrict where people can carry concealed guns. Some states have passed new laws that go against what the Supreme Court said in a previous ruling called Bruin. Now, the Trump administration has decided to get involved. They plan to support removing these restrictive laws when the court hears arguments later this month. This is big news for gun rights supporters. Before we get into the details, I want to mention that subscribing to the channel is one of the best ways to support what we do here. I also want to thank Attorneys on Retainer, one of our main sponsors. When it comes to self-defense legal protection, I believe Attorneys on Retainer stands out from the rest. They have a real law firm backing them called Attorneys for Freedom. They keep adding new benefits to give members the best possible service. One unique thing they offer is a guarantee of 4 attorneys for your self-defense case. No other company provides this. If you want to learn more, check out the links below. Use my code ARMSCHOLAR to get $25 off your sign-up fee. The case we are talking about today is called Woolford v. Lopez. The Supreme Court will decide this case during their current term. Like many recent cases, this one deals with state laws about concealed carry permits. These laws were passed after the Supreme Court made their decision in Bruin, and many believe these new laws go directly against what the court said in that ruling. Recently, something surprising happened. The Trump Department of Justice, led by Attorney General Bondi, decided to step into this case. They filed papers supporting the challenge against Hawaii's concealed carry restrictions. They want these restrictions removed. This may have actually helped the Supreme Court decide to hear the case. Usually, the Supreme Court does not take emergency cases like this one. This case has not even had a final decision yet. It is still in the earlier stages of the legal process. But the Trump DOJ filing their support probably helped convince the court to review it anyway. The Trump DOJ recently asked the Supreme Court if they could participate in the oral arguments scheduled for January 20th. We just got the answer from the Supreme Court, and the news is good. The Supreme Court has agreed to let the Trump administration join the oral arguments happening at the end of this month. Having the current administration on the side of gun rights during these arguments is excellent news. Their participation could help the Supreme Court make a ruling that supports the Second Amendment. If you have not been following this case, let me explain what it is about. The Woolford case challenges new laws that Hawaii passed after the Bruin decision. Hawaii, like several other states, tried to add more restrictions on concealed carry permits. They created a new default rule that works like this. Even if you have a concealed carry permit, you cannot carry your gun on private property that is open to the public unless the property owner gives you clear permission first. The owner has to either put up a sign saying guns are allowed or tell you directly that you can carry there. People who support gun rights sued the state of Hawaii over this law. They argued the law violates the Second Amendment. At first, they won. A judge gave them a temporary restraining order that later became a preliminary injunction. This injunction stopped the law from going into effect. But Hawaii did not give up. They appealed to the Ninth Circuit Court of Appeals. The Ninth Circuit reviewed the case and sided with Hawaii. They overturned the injunction. This meant the restrictive law could go into effect. Because of this decision, the plaintiffs asked the Supreme Court to step in on an emergency basis. As I mentioned, the Supreme Court broke their usual pattern and agreed to hear the case, even though it is still in the early stages and on an emergency timeline. Now briefs have been filed and oral arguments are scheduled for January 20th. The Supreme Court will answer this question. Did the Ninth Circuit make a mistake when they ruled that Hawaii can ban licensed concealed carry permit holders from carrying handguns on private property open to the public unless the property owner clearly gives permission? This ruling conflicts with what the Second Circuit Court said about similar laws. This means the Supreme Court will directly address these broad property bans that Hawaii and other states have passed. These laws were created specifically to get around the Bruin decision. Whatever the Supreme Court decides will affect similar laws in other states too. One important reason the Supreme Court probably decided to hear this case was the brief filed by the Trump DOJ earlier. Now, the Trump administration is jumping in again to support Second Amendment rights. They recently filed a friend of the court brief arguing that the Supreme Court should strike down this broad property ban. The Trump DOJ argues that Hawaii's requirement for property owners to give clear consent violates the Second Amendment. They say the law was designed purely to stop people from carrying concealed weapons in Hawaii. According to the Trump administration, Hawaii was not trying to follow what the Supreme Court said in Bruin. Instead, they had a hidden goal of making it nearly impossible to exercise Second Amendment rights. The brief points out that Hawaii already has traditional trespassing laws that protect property rights. Property owners in Hawaii have always been able to ban guns from their property by simply posting a sign that says no guns allowed. But this new default ban is not really about protecting property rights. The Trump administration argues it is actually about making public carry practically impossible. The goal was to defy the Bruin ruling by expanding gun-free zones until almost everywhere in the state becomes a gun-free zone. In their brief, the Trump administration wrote that this case raises an important question. Does the Second Amendment allow a state to make it illegal for concealed carry license holders to carry firearms on private property open to the public without getting clear permission from the property owner first? The United States government, they argue, has a significant interest in protecting the right to keep and bear arms. They also have an interest in making sure the Second Amendment is interpreted correctly. The United States has presented oral arguments in other Second Amendment cases before. Their participation in this case could really help the court make the right decision. After the Trump DOJ filed their brief, I expected they would ask to participate in the oral arguments on January 20th. That is exactly what happened. Now the Supreme Court has given their answer. They have granted the Trump administration permission to participate in these oral arguments. This is wonderful news. Having the administration on our side during these arguments will likely be very helpful. It could help persuade some Supreme Court justices who already lean towards supporting gun rights. It might even convince justices who are undecided. When you have the presidential administration supporting your position, it always helps your case. In this case, 26 states have filed a friend of the court brief supporting the effort to strike down Hawaii's concealed carry restrictions. However, on the other side, 18 states have filed a brief supporting Hawaii's position. Hawaii recently filed their response with the Supreme Court. They argue that requiring consent before someone carries a gun onto private property follows the Second Amendment perfectly. Hawaii claims the Constitution has never protected a right to enter someone's property with weapons without the owner's permission. Their brief emphasizes that since the founding of our nation, the right to exclude people from your property has been a core part of property ownership. Hawaii believes nothing in the Second Amendment overrides that basic principle. According to Hawaii, this law does not ban carrying guns. Instead, it simply requires permission. That permission can be given verbally, in writing, or through a sign. Hawaii argues that when America was founded, people understood that you did not have an absolute right to carry guns onto someone else's land or property without their consent. Because of this history, they believe their law does not violate the Second Amendment. This case is hugely important for the Second Amendment movement this term. The Supreme Court will once again hear a critical Second Amendment case. They will rule again on concealed carry restrictions. The good news is that we now have confirmation that the Trump administration is on our side. They will participate during oral arguments. They will argue to the Supreme Court in favor of gun rights. All of this will happen on January 20th. This is great news and will likely help push this case toward a positive ruling for the Second Amendment. We are now just a couple weeks away from these oral arguments. These are landmark arguments that will probably help reshape the Second Amendment landscape across the country. I am very curious to see what happens during those oral arguments. As we get more information and as things develop, I will keep you updated. If you enjoyed this video and want to support the channel, one of the best ways is simply to like, comment, and subscribe. Thank you so much for all your support. Never forget that this nation was built by armed scholars, and this nation will be maintained by armed scholars.